Good afternoon, everyone. Welcome to our monthly CLE on conservatorship, visitation, and support. My name is Kristen Salas. I am one of the mentoring attorneys at the Dallas Volunteer Attorney Program, or DVAP, as we call ourselves for short. We are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association, and our primary mission is to match low-income Dallas residents with private attorneys that will do their civil legal cases pro bono. We take a wide variety of cases from family law issues to probate to consumer and expunctions and non-disclosure. So today we're going to learn about how to handle a family law case when there's children involved. And this could be in the context of a divorce with children, or it could be a custody, um, whether it's a parent or not parent trying to get custody of a child. So we are blessed today to have Ebony Rivon speak for us. Ebony started her career in big law at Looper Reed and McGraw, and basically for the past 9 years has been a solo family law attorney and has just done a wide variety of cases. She is very experienced in the family law realm and is a world of information. She got her bachelor's degree from Texas A&M and her JD from Georgetown, and she has been awarded one of the best lawyers from Texas Lawyers Magazine to D Magazine to U.S. News, and a wide variety of organizations for several years. So we are blessed to get her a wealth of information from her. And if you have questions going along in the presentation, please put them in the Q&A. And at the end, she will try to go through those and answer as many as she can. So without further ado, I will turn it over to Ebony.
Well, thank you so much, Kristen and Maricela, for inviting me to speak to our legal aid community here in Dallas or wherever you're joining us from remotely. I'm happy to present this CLE today. And just so that everyone is aware, they will be posting the CLE code in the chat toward the end of the presentation. So let's get started. Today, we will be talking about understanding conservatorship, visitation, and child support in Texas. Now, most people will refer to, or most of your clients will refer to their case as a custody case. But as we lawyers know, there is no such thing as custody in the family code. The word that we refer to it as is conservatorship. And that is how you would ultimately have your clients to start discussing their case and using these language so that they can be familiar with their rights underneath their conservatorship orders. Now, what is a conservatorship? A conservatorship is a conservator is a person with a child-ordered custody of a child. And it is the fact that this is a mother or a father. In some cases, it can be a relative or a grandparent if the child is deceased, but it's basically anyone who has gone before the court or is applying to the court to become the legal guardian of a child, of a minor child. Now, there are 3 different types of conservators in Texas. One, the parties can be what's referred to as joint managing conservators. 2, one person could be a sole managing conservator. And then 3, that would make the other person or parent a possessory conservator. Now, Texas law states that a parent should normally be named a joint managing conservator with the other parent. And this essentially means that you would have joint or shared decision-making abilities in decisions regarding your children, such as education, healthcare, passport, and those sort of things. Now, as a conservator, you will have certain rights and duties to each other and sometimes to the child. The family code in 153.074 discusses some of these rights and duties during your possession and access. Now, one of those is a duty of care, control, protection, and reasonable discipline of your child. So ultimately, to ensure that the child is safe, ensure that you have a controlled and manageable environment. And if a child is getting out of line, you have the duty or responsibility to reasonably discipline your child. All parents have a duty of support to the child. Now, this goes beyond, and we'll actually talk about child support later, but that is the responsibility or the duty to provide food, clothing, shelter, medical care, and dental care to your child. You will have the right to consent to a medical or dental procedure that is an emergency and that does not involve invasive medical treatment. Invasive meaning something that would penetrate the flesh. And then you also, under this provision, you have the right to direct the moral and religious training of the child. And so for some people, that would be determining whether they would be either Christian or Catholic, whether you go to church or don't go to church, and teaching your children right from wrong. Now, in determining whether someone is appointed as a joint managing conservator, that is the presumption in Texas if you are a parent. So a presumption means that when you walk into court without hearing any facts, the court is likely going to appoint mom and dad as joint managing conservator. Now, that would be only if this appointment would not significantly impair the child's physical health or emotional development. Okay, those are going to be the key words: physical health and emotional development. Now, if your case has facts that show that appointing both parents as the joint managing conservator would impair the child, then you would ask to be appointed as the sole managing conservator of the child, and for the other parent to be a possessory conservator. This is what we refer to as rebutting the presumption. It is the ability to present evidence to the court that says, Your Honor, while I understand that joint managing conservator is the default here in Texas, I do have some facts to show that it would impair the child's physical health or emotional well-being. And so I am asking to be appointed the sole managing conservator. Now, one of the ways that you can rebut the presumption is to show that there has been a history of family violence involving the parents of the child. That is something that can overturn or essentially to rebut the presumption of joint managing conservator. Now, as a sole managing conservator, that parent will be asking the court to award them to have the exclusive rights under Texas Family Code 153.132. And that would be the exclusive right to determine the primary residence of the child. Informally, a lot of people will refer to this as being the primary parent. The second right would be the exclusive to be able to consent to medical, dental, and surgical treatment involving invasive procedures. So this would be in order to have surgery. Let's say you need to have your child's wisdom teeth removed. These would be examples of invasive procedures. The exclusive right to consent to psychiatric and psychological treatment. The exclusive right to receive child support. Again, noting we will talk about child support later in this presentation. The exclusive right to represent the child in legal action and make decisions make other decisions of substantial legal significance concerning that child. The exclusive right to allow that particular child to enlist in the armed forces. The right to make decisions concerning the child's education. The right to receive earnings and services of the child. The right to, if there's not a guardian involved, the right to be that child's agent in a matter regarding the state, the U.S. government, or foreign government. And lastly, the right to apply, maintain, and renew the child's passport. So if the court finds that their appointment of both parents making or sharing these rights would impair the child, These are the rights that you could ask to be awarded exclusively. Now, in the alternative, sometimes you have situations where the parent may just be better at making certain decisions versus the other parent. In those situations, you can still proceed as joint managing conservators, but ask that one parent have the exclusive right to make certain decisions. A perfect example would be if a child has a very difficult medical past and one parent is a pediatrician. There are some circumstances where the court can look at the evidence and say, given this person's ability and their history in the field, they should be awarded the exclusive right. But mom, dad, you have to consult with the other parent before you make any of those decisions. Um, in the opposite, I've had a case where I've had a parent who was a pediatrician, but unfortunately, because of her being a pediatrician, she was taking the child to a lot of unnecessary appointments, having her take unnecessary tests. And the court actually took her right away and said, because of your experience in this medical field, it kind of makes you almost a hypochondriac in that every illness that a child has requires medical treatment. So I'm going to allow dad, because he's a sort of a step removed, to make those decisions. But again, he has to consult with you first. And so regarding conservatorship, in order to determine how the court is going to rule, the court is going to figure out what is in the best interest of the child. This is family law. You're going to hear best interest a lot because it is the governing standard in most child custody cases. Now, if you look at the Texas Family Code, section 153.002, it talks about and describes what is the best interest of the child. Now, in many of these cases, in order to award conservatorship, possession, and support, the court will be asking, is the award or potentially an agreement of the parties in the child's best interest? Now, if you look to the case law, there is a governing case that describes in detail what factors or facts the court should specifically look at in determining what is in the best interest. And these are the Holley factors. And they come out of the Texas Supreme Court case, Holley, and that's Holley versus Adams. Now, when determining conservatorship, again, visitation and support, the court is going to entertain, well, what is the desire of the child? If you realize later in the code, it does state that one of the factors the court can use to determine is if a child has stated, if they're over 12, they want to reside with the parent. It is just a factor, but think of it as the scale of justice. Sometimes it can tilt it forward, sometimes it can tilt it back, but it's not the deciding factor. So when you're talking with your parents and your clients, please remind them that that is just a factor and what the child wants does not govern. The court will also look at the emotional, physical needs of the child now, and then also in the future, the emotional and physical danger of the child now and in the future, the parental abilities of the person seeking to have conservatorship, the programs that are available to the parties that could promote what is in the best interest, what is the plan of that particular parent for the child that's seeking conservator. The court can look at the stability of a home or proposed placement, the acts or the omissions of a parent trying to become the conservator, and also any omissions of that particular parents and excuses used as to determine what's in the child's best interest. So the case that lines out and identifies some factors that I would say that you could kind of go through in your cases, essentially line by line and doing your questioning to make your best evidence to the court that these are all the reasons that support my client being awarded either the joint managing conservator or sole managing conservator. But the court can also look at other factors outside of these Holley factors to determine what's in the child's best interest. The court can look at the parent's past decisions of the child. For instance, whether a parent acted promptly to a child's medical need, an educational need, or an emotional need. The court can look at whether this particular parent has a previous history of complying with court orders or violating court orders. And then third of all, the court can look at whether the parent has actually met the needs of the child to determine whether or not which conservatorship is appropriate. Now, again, in your custody cases, always remember that the court is going to be deciding what is the best interest. So if I were you, try to get as many facts as you can to confirm and to lay out kind of plainly to the court, these are 10 reasons why the court should place the child with your client and while he or she should be appointed as a joint managing conservator or a sole managing conservator. Next, we did already talk briefly about rebutting the presumptions and what is the presumptions under the code. Again, history of family violence, child abuse, neglect are definitely the key areas you want to bring to the court's attention if you're fighting for your parent to become a joint managing conservator or evidence of why they shouldn't be and you should be appointed as the sole managing conservator. Now, these presumptions also apply to child support, but again, we'll get to that one later. Next, let's talk about visitation, or what we refer to possession and access in the family code. Now, most people have heard about the standard possession order. Most clients would have heard about the standard possession order. And ultimately, what this is a possession schedule or a parenting plan that the legislation has put together to determine this is the minimum amount a parent should be able to see their child if that child is above the age of 3. Now, we'll deal with different visitation schedules with children below the age of 3. But again, when we're talking about the standard possession order in Texas court, it will be the presumption that it is in the best interest of the child. Now, let's deep dive a little bit into what is involved or what are the components of a standard possession order. At the very beginning, it's going to include some definitions. It's going to talk about child and children. It's going to address school, because ultimately most kids are going to be in school when the parents are exercising these visitation schedules. Again, because we're talking about right now over the age of 3. So with possession schedules, we're going to talk about the custodial parent. And what that means is the person who the child resides with, and the non-custodial parent. This is going to be the parent who is exercising possession and access with their child. So if they live 100 miles or less, the standard possession order will give the non-custodial parent the first, third, and fifth weekends of the month. Now, it's very key to note that weekends technically mean the first Friday of the month. So if you're looking at a calendar, be sure to note for your clients that what they actually need to look at is Fridays and not necessarily weekends in a particular month. So it would be the first, third, and fifth Fridays of the month, Thursday evenings after school, generally between 6 to 8. They would alternate holidays, and then they'll have extended period of possession during the summer, which is about 30 days. And we'll go into some of these in more detail later. Now, if a parent resides over 100 miles, then that particular parent has a choice. They can determine if they want to exercise the first, third, and fifth weekends of the month, or they can advise the parent they want to exercise one weekend per month with that particular child, and they need to notify the parent 14 days in advance of their intent to exercise that visitation schedule. Now, obviously, this is meant so that the child is not spent driving back and forth or being flown back and forth unnecessarily if the parent can't actually exercise that visitation schedule. Again, you should encourage your clients to be sure to think about, how would it feel like if you had to do this much traveling every other weekend, essentially, and to think about what's in the child's best interest and not necessarily in the parent's best interest. Now, also, with the over 100 miles, there is no midweek visit. Okay. The holidays remain the same, except that in this particular circumstance, the non-custodial parent would get every spring break. And instead of 30 days in the summer, they get 42 days in the summer. Now, with the summer access, regardless of it, if it is a custodial, over 100 miles or under 100 miles, the key is that if they give the party notice by April 1st, that allows them to determine if they want to break up their visitation schedule into 2 parts, or if they'll have a consistent, consecutive 30 days if they're under 100 miles, or 42 days if they're over 100 miles. And that would be from June 15th through July 27th. So this is something you always want to highlight and put on your calendar if you're an attorney for April 1st to kind of send that reminder, or if you do chats or blogs to remind parents, hey, it's April 1st. Don't forget to send out your notifications to the parent about your intent for your summer possession. Now, holidays. In 153.314 of the Texas Family Code, it talks about the Christmas holiday. Now, because Christmas is such a lengthy break, most parents will either have the A possession in one year and then a B possession in the other year. The A possession is from when the time is either at 6 p.m. Until noon on December the 28th. I apologize, December 28th. So that means that you would have the Christmas portion of the schedule. And then the next year, it would flip. You would have from December the 28th at noon until the Sunday before school resumes at 6 p.m. for that particular child. And in the code, it does break out which parent, whether you're the custodial parent or not, has odd years or even number years. Thanksgiving. The Thanksgiving week is not divided like you would have the Christmas holiday. It is for the entire week period. And so depending on if it's an odd number year or an even number year, you would have that particular Thanksgiving from 6 p.m. from the Friday when school gets dismissed for the holiday period, and return the child at 6 p.m. the following Sunday. In all orders, you are entitled to have possession of the child on his or her actual birthday from 6 p.m. to 8 p.m. And then you are generally awarded Mother's Day weekend and Father's Day weekend. And so depending on if you have the mother or the father, this is something that most parents really love and look forward to. And so generally they exercise their Mother's Day weekend and Father's Day weekend possession. The last sort of deviation that is helpful for parents to remember is that if there is a holiday on the Friday or the Monday before a possession period begins or ends, then the child's possession, the parent's possession period is extended by those holidays. So for instance, if it was Martin Luther King Day on Monday, January 15th, and it was your weekend, instead of returning Sunday at 6, you would be allowed to return the child on Monday at 6. Now, again, communication is key in these cases. So I always encourage my clients to let the other parent know if you plan to exercise this additional possession or not. Next, one of the things that have changed recently in the law is to allow the automatic expansion of the standard possession order, and allow for the alternative beginning and ending periods to be expanded. Now, this is under 153.317. And ultimately, what it says is that instead of picking the child up at 6 p.m. on those Fridays, you would pick the child up at the time school is regularly dismissed. So let's say your child's in school, gets out at 3 p.m. Instead of waiting until 6 p.m. and meeting the parent at their home, you could go directly to the child's school and pick the child up. And then instead of returning the child on Sunday at 6 p.m., you would return the child on Monday morning at the time school resumes that following weekend. So in addition, the expanded standard possession order allows for a midweek overnight. So remember, we talked about on Thursday, you'd be allowed to pick the child up from 6 a.m. and return the child at 8 p.m. Now you'll be allowed to pick up the child on Thursday from when school is dismissed. You take the child to school back on Friday. And if it's your weekend, you would pick the child back up on Friday and return the child back to school on Monday. A lot of parents are loving to have this additional time with their children. Also, it helps them feel like they're not just a quote unquote weekend parent that some people get frustrated at. And so you can always let your client know that if they live under 50 miles, they're allowed to automatically make this um, election of having the expanded standard possession order. And it also includes um, expanding the time also from the spring break visitation periods to picking up from when school is dismissed, returning to when school starts. You would have the expansion of being able to pick it up from the Christmas school vacation, the Thanksgiving school period, the Father's Day and Mother's Day period, and the holiday weekends. So, mind you, again, this for especially cases that have higher conflict, it allows less parental interaction with each other. So that's something that helps because it allows to reduce the conflict. So if the parents are allowed and it works, then encourage them to elect their expanded weekends. Now, again, we did talk about that this can be automatically exercised by the parents if they're less than 50 miles. However, um, if there is a problem and this is actually unworkable, it is something that can be rebutted. And so ultimately, you would communicate to the judge, Your Honor, I understand that this is allowed per the code. However, 50 miles results in the child, 50 miles of where the parent lives results in, mom or dad having to drive to school, for 2 hours. And so the child is having to wake up at 4 o'clock every morning. And by the time the child gets to school halfway through her day, she's sleepy because she's been up so early. And so that would be potentially a circumstances. Well, yes, you're less than 50 miles, but because of traffic or whatever circumstances, it takes the child 2 hours to ride in a car, which, is not in the child's best interest. So again, this can be rebutted in order to make it more workable for the child, because again, we are always thinking about what is in the child's best interest. Now, other types of possession schedules that we may deal with are what's called modified possession schedules. Frequently, and I apologize for the noise downtown Dallas with the sirens, but frequently we do have courts and parents who are requesting 50-50 possession and access schedules. So the possession order schedule can look like 1 week on, 1 week off. It could be a 2-2-5 schedule where the parents have 2 days, the other parent has 2 days, and then there's a 5-day possession period. There could be times where there are, if it's a younger child, no all-day periods and no overnights. It could go 2 weeks on and 2 weeks off. We're lawyers, okay? So when it comes to these possession schedules, we get very creative. And sometimes we do have to think about the work schedule of the parent, or we have to think about any special needs of the child. And so it can deviate from a standard possession order, and you can get very creative because, again, the point is to determine what's in the best interest of this particular child. Now, I've been throwing in there, I've been bringing up the topic of possession orders under the age of 3. So because a child is under the age of 3, they are more developmental. If a parent is not necessarily having frequent and consistent access, it could be very traumatizing for a child to have very lengthy possession periods away from the home parent to be with the non-custodial parent. And so the court will take these different circumstances into consideration when creating a schedule for a child under the age of 3. So factors that your court can consider, and this will be in the Texas Family Code 153.254, and that would be the caregiving provided to the child before and during the pending case, the effect of the child that the schedule may have from separating from the other party, the availability of the parties to actually be caregivers and the willingness of that parent to personally provide the care to the child. And I always find this one particularly interesting because sometimes we have parents who just want the visitation schedule in place, but then pawn off the child to another individual, which could be, a sister, or aunt, or grandmother. The court does actually look into the availability of that parent and the willingness to personally care for this child under 3. The court can consider the physical, medical, behavioral, and developmental needs of the child, the physical, medical, emotional, economic, and social conditions of the parties, so essentially their environment, the impact of influence of those individuals during the case and before the case, the presence of siblings in the home during the possession periods, the child's need to develop healthy attachments to both parents, the child's need to have a continuing routine or a sense of a routine in their possession schedule, the location and the proximity of the parties of both of the parents, as well as a temporary schedule, which can shift these particular factors. Now, obviously, even on the spectrum from the age of 1 to 3, there's still a range, right? So if you have a newborn child who may be breastfeeding, or a child under the age of 1 that is breastfeeding, it may have to, the possession schedule may have to be just frequency in hours versus frequency in days for a child that's maybe older and closer to the age of 3. But at the end of the day, you would want to present any evidence of what is in the child's best interest and any unique factors that may be going on with the child in your case or the parents in your case to determine what is in the child's best interest. Now, let's say we have a situation where we discuss that family violence can be a reason that a person is awarded, is only awarded as a possessory conservative. Then you have to start thinking, okay, this parent is entitled to possession, but what should it look like? Okay. The judge has to be concerned about the safety of a child at all time and whether or not that child should be supervised with their parent or their conservator or not. Now, for a supervised possession plans, the supervised access can be supervised by a family member, a neutral third party, or an agency, such as the family place or family life, I think it's Faith Liberty Place, which is a third party entity. Sometimes it can be required to be at a public place so that the child's not in a home and that if something dangerous were to happen, that there potentially would be others who could see it and call for help. So given the family violence or the particular violence, or if someone has limitations, that would be one of the facts that you would want to consider in determining whether or not you would request or want the court to order that a conservator has supervised access. And then in very rare exceptions or in cases, the court can award that a parent has or a conservator has no access at all with a child. A particular instance could be that if the parent had a drug problem and needed to work on their sobriety first, if the judge may order that the parent may have to go through some counseling first to identify and their behaviors and learn some coping skills and how to interact with the child. But there are different situations where the court can say that, you know what, even supervised would not be in the best interest of the child. So for a limited amount of time, in order to protect the child's physical and emotional needs, we're going to say no visitation. Next, child support. Under Texas law, we've already discussed that the parents and the conservators or the conservators have a duty to support their children. And this, in addition to financially supporting the children, also to provide health insurance and medical support and or dental support. So child support essentially is money that a parent uses to pay for the costs associated with raising a child, food, clothing, housing, daycare, activities, etc. And a court can order one conservator or one parent to pay this to the other through a court order. I always encourage people. I know that they don't sometimes want to be involved in court systems and be involved in the system, but it's so paramount for these parents to get child support orders so that they can alleviate confusion. Now, some parents don't need that, and that's great. But any parent that's talking to a family law attorney obviously has conflict and will likely need to get some type of a child support order. And in rare cases, you may be able to get them back child support or retroactive child support, depending on their circumstances. Now, in child support, we're going to use terms such as payor or obligor, and that's the person who pays child support. And then you have the payee is the person or obligee, and that's the person receiving the child support. The Texas Family Code, section 154.125, lays out how one party determines child support. Now, with few exceptions, child support is going to be based upon the net income of all sources of income for the payer. And for net resources, some examples that you would want to consider are wages, overtime, tips, bonuses, commissions, SSDI, VA disability, unemployment, Social Security, retirement, any apps, any employment from whether it's your own business or self-employed income, or employment from a third party such as rideshare or delivery apps. And that started in September of 2021. The things that are not allowed to be included in the net resources are supplemental security income, or SSI, a VA pension, or TANFs, which are benefits from the state. In calculating the child support, the only things that are going to be subtracted from that party's net resources are Social Security and Medicaid taxes, income taxes for a single person, the cost of health insurance, dental insurance, or medical support for a child, if that person is providing it, and union dues. Okay, so generally those are the things that come out of a party's gross resources that allows us to determine what the net income would be. Now, in Texas, and this number will change every year or two, right now, the max award of child support can be up to $9,200 per month of a person's net resources. Now, to determine guideline child support, there is a chart that you can look at to determine what percentage of your net monthly income should be provided to child support. Generally, if there's one child before the court and no other children of which that person has an obligation to support, it's 20%. For 2 children, it's 25%. For 3 children, it's 30%, and it goes up. Now, there is a different variable and a different chart for individuals who do have children outside of this your particular pending case. And so if there's one child before the case and one child outside of the court, the percentage would be 17.5%. If there's one child before the court and 2 outside the court, it's 16%. And so I would always encourage people, if you remember the State Bar of Texas Family Law section, you will get your booklet every year, and there's a page that has all of these charts that allow you to kind of flip to turn to determine exactly what percentage your parent would either be receiving or be paying. Now, again, in September of 2021, the law changed child support provisions for individuals whose net monthly resources are less than $1,000. And that's in the Texas Family Code 154.125C. And so a person who has income with less than $1,000 will have a lower percentage point than if they were above that mark. So for instance, we talked about if there's one child before the court and 0 outside of the court, that parent would pay 20%. In this scenario, if it was less than $1,000, they would only pay 15%. Instead of 25% with 2 children, it will go down to 20%. And then for each number of child it would continue to increase by 5%. And so I know that people were really happy for this adjustment just because lower income individuals do not have a lot of money. And so they find this to be fairer and in the child's best interest. Now, the length of time that a person can be obligated to pay child support is until that particular child turns 18 or graduates from high school, whichever occurs later. And so I know a lot of times people have instances where the child turns 18 and they're like, woohoo, I'm off of child support. And I'm like, well, not so fast, because you have to wait until that person graduates from high school. Now, if you have a child who is disabled, it could last longer. And you would have to petition the court with the specific details and facts about why your child is disabled. It would have to be supported by medical documents or the child's medical records to state why you would need child support past the age of 18. And this is generally for children who can't support themselves and will need support for the rest of their life. Now, also, sometimes parents have their parental rights terminated. How so? You may need to look at your court order or how they are in the process of a case, because just because your rights and duties to your rights may be terminated toward a child, your duty may not be terminated. So you could still be ordered to pay child support even if your rights have been terminated. So for instance, this could be situations with adoptions or situations with CPS cases where your rights have been terminated due to some type of neglect or abuse toward that child. Now, for child support, this is very, very important. The definition of child support is the payment of funds from the non-custodial parent through the state distribution unit to the custodial parent. And so this means that all payments must go through the Texas Child Support Distribution Unit. And what they do is they record the payment. The custodial parent would create an account, and then the funds would be released to that particular parent. If a parent decides to make a child support payment outside of the state distribution unit, then these payments could be seen as gifts or not credit towards your child support amount and could start creating an arrearage. And remind your clients, any arrearage payments are going to be charged at 6%. So you want to make sure they are paying to the child support distribution unit, so that is properly registered and accounted and then sent to the non-custodial parent. Going back to termination of child support, the provision is 154.006. And in addition, I wanted to bring to everyone's attention the failure to comply with enrollment or attendance requirements in the code. So an example is if you have a child that's not going to school, or let's say a child is continually being held back in school, and part of that is because of the mother's behavior, I'll say the custodial parent's behavior, because it could be mother or father's. You could petition the court to say, Your Honor, I think my child support should be terminated. This child has been held back 2 years because the mother doesn't make him or her go to school, and he hasn't graduated yet, but the child is about to be 20 and I don't feel like I should be on support anymore. In some instances, the court will terminate due to under those facts. And so it is a provision that is allowed. And so that's something you would kind of want to keep in the back of your head if they're not properly matriculating. Another reason to terminate it early would be if the child enlists in the armed forces, and whether or not, if it was determined through genetic testing that potentially you were not the biological father of the child. And this will be in a case of mistaken identity and mistaken paternity type of cases. Now, there's also provisions of modifying and enforcing child support and possession and access, but I was told that we're going to leave those topics for a later date. But one thing I will always remind my clients is that visitation and your possession and access is going to be a completely different provision than your child support. So, for instance, if a parent is not exercising any possession and access, they're still required to pay child support. And just because someone is paying child support doesn't mean that they may want to exercise possession and access. And you can't penalize one parent for doing one and not the other. Think of them as two completely different and separate roles. And that way it's easier to, to kind of clear up the water when someone is saying, well, they're not paying child support and a parent may try to withhold the child for that reason. The court, unfortunately, will not allow that. And that could just lead to a circumstance where they both could be in contempt of court, one for failing to pay child support, and then the other parent for withholding the child in violation of the possession and access order. So with that, I don't know if we have any questions or answers, but I was told to leave some time for Q&A. I don't know if I can see them.
We don't see any questions in the chat or the Q&A currently. But thank you, Ebony, for your presentation. And while we wait for y'all, if you want to submit questions, I'm going to go ahead and list the MCLE course code. And that course code is 174250371. Again, that is 174250371. And I'll also put it in the chat since I'm losing my voice today in case I sound a little low. Looks we have a question. So the question is, what do you think about a 50-50 possession schedule for Dallas County judges? Is it more favorable these days?
I think that a lot more judges in Dallas County are awarding 50-50 schedules. But I think it really depends on the circumstances. There is in my experience, I would say it really depends on the parent's ability to co-parent. So if they have a good working relationship, then 50-50 makes sense. Also, sometimes the age of the child makes more sense to do 50-50 just because of the kid's schedule, but it is very fact intensive. A lot of judges are also on alert that some people just want 50-50 schedules because they don't want to pay child support. And so I like that judges in some circumstances will do an offset of child support if there is 50-50, meaning that that whoever, basically whoever makes the most is the one who pays. And it goes back to the idea of how much funds or resources would have been available to the child if the parents were living together. So I do think it is more favorable. I do think you have to kind of make sure you have parents who can work with each other. And then also, I do think you have to be concerned about the child because a lot of kids don't like moving back and forth a lot. And so that's when you go into whether a 50-50 schedule looks like a week on, week off versus a 2-2-5 versus a 2-week on, 2-week off.
Great, thank you. What about if there is a divorce upon realizing that one parent is on the spectrum, high functioning, and is making irrational decisions? Will the court likely award full custody to the other spouse?
Great question. So with that parent, I guess, again, you'd have to go back and see whether or not you have enough evidence to prove that their irrational decisions are significantly impairing the child. So my question kind of would be, and if you can type it, are they making irrational decisions regarding the child or just irrational life decisions? Are decisions irrational because the other parent doesn't agree with them, or would a reasonable parent disagree with them? And so that is something that I would definitely say that just because someone is on the spectrum and high functioning, that by itself, I don't think would be enough evidence to take away a person's right to make decisions regarding their child. But it may be a situation where they're still joint managing conservators, but someone has exclusive rights in certain categories and the other ones are jointly exercised, but maybe not have to be exercised by subject of agreement. But maybe one person, when it may be this medical decisions, that it's, one parent has the exclusive right to determine, to make a decision, but after consulting and doing a meaningful consultation with the other parent.
You. And another question, as the child grows, how much input or control does the child have? For instance, if the child does not want to visit according to the schedule, what is the process the child must take?
This one is always tricky. I think so. Children are children, and children don't make decisions. Is my opinion, and what I believe the judges normally believe. And it becomes a situation if a child doesn't want to go to a parent's visitation schedule. I mean, don't want to follow the visitation schedule. I think you need to ask why. So is the child being put in a dangerous environment? Is it in a healthy environment? Then you have to ask why. Because if a child just doesn't want to do something, I always ask my client, well, what would you do if your child didn't want to brush their teeth? Or with teenage boys, when they don't want to shower, do you make them do it anyway? And generally the answer is, well, obviously, yes. And so I tell them, well, that's what you're going to have to do. I understand they don't want to go, but you're a child. You don't get what you want. The parents are the ones who make the decisions about what's in the children's best interest. So if it's not a harmful or neglectful environment, then maybe the parents need to go. Maybe the child and parent may need some therapy to work through their issues, or maybe you can suggest it, because you really want to get down to the root of the why. Now, I do know that with children who get older, they have all their activities, right? They play on the football team. And then so after the football team, they want to hang out with their friends and they want to, go to the parties. And if the other parent lives out of town, then they don't get to do that as much. And then that becomes a situation where it's hard for the court to jump in and say what is right and what is wrong. Hopefully you would want a parent to take into consideration the fact that a child is getting older and has, other desires and is not directly, I don't like this other parent or don't want to do these things in a negative way, but right now they're a teenager and they want to do teenager things. I've seen a court put into place a provision called an older child provision, where that child and that parent can come to an agreement or understanding about when they want their possession schedules to be. But that in that particular instance, or the few times I've seen it, it is because a child who has a lot of extracurricular activities. This one particular child was actually a top 15 on the junior tennis arena. So he was highly competitive in tennis. And so the court put it in place because of his future and scholarships, et cetera. The other time I've seen it put in place is when the parent didn't have a consistent relationship with the child. And so while he had a possession and access schedule, he didn't comply with it on a regular basis, kind of for months and weeks at a time. And then he would just kind of want to pop up and then say, it's my weekend and go. And so the court did put in place an older child provision that kind of says, okay, well, this kid has a schedule and want to maintain the child's schedule. If you can maybe get on schedule, then we can maybe revisit this. But I have seen it, and it's really facts intensive. But ultimately, I never think that the child should be able to determine when they should go or when they shouldn't go, because they're a child. And once they can say and run things in the other parent's home, it's not going to be long before they're trying to do it in your home as well. So just be very careful with the door that you open.
All right, no additional questions. Again, thank you, Ebony, for your wonderful presentation. Very informative. Thank you for everyone who attended this afternoon. There was a question about whether the session was recorded. It is, and we usually upload those to a link later. So if you have any questions about getting the copy of the link, please reach out to me directly. And I've included my email to the, one more. And everyone says, thank you, Ebony. So
Thank
thank you
you.
all, and have a great rest of your afternoon. Bye, everyone.
Bye.